Hello again. I just put considerable effort into outlining my personal injury practice. Let's get back to some family law and something called the modification process. I mentioned in my introductory video that the do-it-yourself forms that the Supreme Court has a petition for modification form. And there's a little space, you can write about that much. Why do you want your parenting plan or your custody arrangement changed? It can be other things. It can be the amount of child support, which is pretty much controlled by a statute and a formula. So we tend to go back over the parenting plan issues more than any other modification issue. Or somebody wants to move 10 hours away. Those are very significant. And there's a statute, it's called the relocation statute. But the do-it-yourself forms don't give you a copy of the relocation statute. They just give you a relocation form to fill out. The modification form doesn't tell you what the basic grounds for modification are. There has to be a substantial and material change in circumstances, such as the 10-hour move or something else. A remarriage is not supposed to be a reason. That was tended to be used against women with limited incomes. They marry some guy and the kids have trouble with the new stepdad, and now they're going to petition the court to change that. But there are other things. There can simply be minor changes that the parties need to work on. And I'll get to that in a moment. I don't think those should go to petitions to modify. I think there's a better route, and I'll tell you why in a moment. But if the parties followed a different parenting plan, if the parties followed a different parenting plan for over 6 months voluntarily, without any coercion by either side, then you can file a petition without a change in circumstances based on the de facto arrangement. Or there's one called manifestly harmful to the child. The parenting plan is not working as anticipated, and therefore it needs to be revised. And a variety of things like that. But the substantial and material change in circumstances should be in almost every petition. If you don't draft that properly, I'll tell you what I do from the other side is I just move to dismiss it for failing to state a cause of action on its face. And sometimes that's the case. Now, I was surprised to find recently a family court judge who did not believe that an order requiring the parties to go to mediation before they went back to court against each other was really a binding order. He said it was just a suggestion. It said, alternate dispute resolution mechanism, mediation. The parties will return to mediation to resolve any differences arising from this plan. There are other judges, fortunately, who agree with me that if the judge says you will go to mediation on matters that fall short of serious abuse or danger, you got to do that. And that's one of the revolutionary things I put in my new proposed mediation rules is that the parties, if they agree to do that, will be bound to do that. And I have a handout, an article that explains to people how to enforce their parenting plans and how eventually, if needed, to require the other side to return to mediation. Now, I'm a great believer in legal aid. I was the attorney of the year in Upshur County for many years, the attorney who did the most legal aid subsidized work, which was at a very low rate, but when you're the new guy in town, every little bit helps. And I learned that legal aid has a policy of not putting a mandatory mediation provision in the parenting plan, even though the Supreme Court form has it pre-printed. And I have been taught that it's required to have an alternate dispute mechanism listed there. They get their clients based on a formula, and they don't get to mediate those cases. So if their own self-interest is, if they require mediation, they say, well, that'll deprive that person of their day in court. Well, what if that person no longer is eligible for your services? Or what if your funds have run out, as they periodically do year after year, and they can't get you as their lawyer in a court case, and you haven't put a provision in there before where they can make the other side go to mediation and save the money of the court case? So it's funny that even a group of selfless attorneys and an organization designed to create access to justice will deprive people of justice because in their mind it might keep them from getting new cases if they got mediated without a lawsuit. Does that make any sense to you? I'm sorry, it doesn't make a bit of sense to me. So the modification at that point we'll have the other side get served, and we serve them in person, although you can do it by mail. I prefer to have it served in person, but to give them the opportunity to come down to the sheriff's department and accept the paperwork. They have 20 days to answer, and the court will issue its scheduling order. And we'll have an initial hearing to see if anything needs to be changed right away. And recently in a case, unfortunately for us, the court did fine-tune it without hearing any evidence. And it made it very difficult to negotiate a solution to the case because we couldn't offer to make that one change. The other side thought they already had it. So it was frustrating. Most of the time the court will not modify at the temporary hearing, but may make adjustments if there's a distinct change in work schedule or something like that. The court will decide whether the parties will pursue discovery. We will usually file a motion for temporary relief. We almost always ask for at least the right to file some discovery. I talk about discovery in my presentation on the framework of a family law case. And normally the court will order people in that situation to go to mediation. I'm going to talk about mediation later. We can defend very effectively petitions to modify. If it's a move 30, 40 minutes away that does not require a modification of the plan, then they get to make that move, and the plan doesn't get modified. Generally, the schooling goes with the parent who has primary residential care. Let me talk about that, since I did not talk about it in my general talk on the family law system. The new statute has done away with the caretaking functions form that you used to have to fill out. The old law would try to follow what you had been doing, you and your spouse had been doing for the year prior to separation at the temporary hearing, and then look back 2 years at the final hearing and pretty much do what the parties had been doing. Well, in the case where the one spouse was working 2 jobs and just killing herself or killing himself to get the work done, holding them to that schedule was terribly unfair. I had one fellow give up his job going out of state to work for a tree company, Davy Tree Company, and he started a body shop in the garage next to his residence. He was able to monitor the kids, they were able to play in the backyard, and he was able to work on his body shop, and the judge gave that man, and this is a 10-year-old case, so I can talk about it, every other weekend, because that's what the judge would have given him if the guy still was away 9 out of every 14 or 15, or 9 or 10 out of every 14 days. So the new law is more of a presumption of a 50-50 parenting arrangement. If you've got 50-50 and one person makes twice as much money as the other, there will still be some payment of child support. If it's a 60-40 plan, the formula is called the extended shares formula, and you pay less than you would if the other parent has what the courts used to call full custody. Full custody, as a rule of thumb, would be 65% or more of the time. And then there's another crazy percentage, an older statute that still focus on this caretaking functions concept, says that if the one parent has 70% or more, that's called the substantial majority of caretaking, and they want to move to another location, say Columbus, Ohio, or St. Louis, Missouri, and they have a good reason, and it would promote generally the benefit of the child by parent maybe making more money or having a new stable relationship with a new husband, that they are probably going to be allowed to move. And if the person has less than 70%, the presumption goes against them. At the present time, I have to admit that whether or not a parent gets to relocate with a child appears to be generally roulette or a crapshoot. It just depends on how things had existed before that move came up. And I believe there is law being made right now. There was a case that pointed out early last year that even if the overnights awarded were the 70% or less than 70%, if one of the parents was really doing more than 70% of all the caretaking functions, they would still get the right of that presumption. And it was because there was one parent that was holding her own and doing most of this stuff, and the other guy had a court order giving him better than a third of the time, better than 30% of the time, but he wasn't really doing those things. So they're heartbreaking, because you see one person with an opportunity to start a new life, you see somebody else that loves their child and doesn't want that child to leave, and those are the worst ones to mediate. It's very hard to come up with a compromise on a case like that. These are the cases where you need to have a good attorney to represent you. I offer our services and my expertise in these areas. Again, it's area code 304-472-7477. It's a website, www.hunterlawfirm.net. And you just click on my blog if you want to and search for any of these subjects. But remember, reach out to me. If you only have a small sum of money, say $500, and you don't think you need an attorney, or you don't think you're going to be able to afford an attorney, that $500 will give you at least $1,000 worth of information from me. My forms, my checklist, my book, my ideas, and with those things, many people decide it's time to give a call to grandma or grandpa, or somehow figure out a way to have the representations. But I'd like to think that the ones that go forward with that information versus somebody who never had that information shared with them has an edge even when they're unrepresented. That is called Unbundled Legal Services. It's an innovation that's swept the nation and has been very popular for years in other states, but not so much West Virginia. And when I discovered it while I was the chair of the West Virginia State Bar Future of the Law Committee, I strongly recommended it to my colleagues. I haven't gotten a lot of feedback. Lawyers don't like change very much, which is amazing, because I'm sitting in Buchanan. My childhood love was science fiction. Watching change happen faster than I had ever dreamed it could change, watching some things stay the same that shouldn't stay the same, and trying to learn new ways to do things. So come to our office, and you may see someone with gray hair, but you won't see somebody who's afraid to try something new. Come on, button.